right, let's get started. Good afternoon, everybody. It's really wonderful to see so many of you here in the room, and there are more people joining us online, even though we can't see them. They are there. My name is Anne Saad. I'm an associate professor in the International Law Department here at the Graduate Institute, as well as a faculty associate at the Center for International Environmental Studies here. And I'm absolutely delighted to welcome today Professor Jimena Fuentes Torrijos to speak on an incredibly timely and important topic, the role of science in the resolution of disputes regarding international water resources. And I'm equally delighted and really grateful to our colleagues from the Geneva Water Hub at the University of Geneva, Professor Mara Tinino and Professor Laurence Poisson de Chazoum, for initiating this collaboration. And we're really happy to host you all here at the Graduate Institute, and we look forward to having many more collaborations in the future. I'm going to keep it very brief, and I will hand over to Professor Poisson de Chazoum. Maybe should I say something about timing? Perhaps I should say just a little word on well, I'm not going to time you, so don't worry. But just to let our audience know that there will be time for questions and answers at the end. So both for everybody in the room as well as those of you who are joining online, if you have any questions, don't hesitate, you will have time to ask them at the end. So let me now give the floor to Professor Poisson.
Thank you, Professor Saab, and thank you to Professor Uftit, who was also involved in the organization of this joint event. I'd like to thank the Center for International Environmental Policies for doing that with the Geneva Water Hub. The director is sitting in front of me. And Mara Tinino and myself are part of the legal component of the Geneva Water Hub, which is the platform on international water law. So today is a great day for us in Geneva because we're welcoming Professor Jimena Fuentes Torrijos. She is a professor, well-known scholar. I'd like to mention a book that she's written, which is The Criteria of Equitable Utilization of International Watercourses in General International Law. And I mentioned this topic because it's a topic which is going to become a more and more acute topic in international relations. Jimena Fuentes Torrijos is also the Vice Minister of Foreign Affairs of Chile. And for that, we are very grateful that she found time to come to Geneva. Jimena Fuentes Torrijos has been involved as taught in many universities, and she has also been involved in proceedings before the International Court of Justice. Recently, Chile was part of 3 cases which were brought before the International Court of Justice. So she served as an attorney advisor to Chile in the lawsuit filed by Peru. And then she was the executive coordinator of Chile's defense in the case obligation to negotiate access to the Pacific Ocean, a case brought by Bolivia against Chile. And then in 2016, she was appointed as agent of Chile for the case against Bolivia, which is on the status and the use of the Silala waters, and I'm sure that we're going to hear quite a lot about this case and the experience that we can be drawn from the case. So before that, Jimena, although being a professor and a writer, was the National Director of Borders and Boundaries of the state in Chile, so she knows a lot also about boundaries issues and political issues which are linked to these issues. So without further ado, we're very grateful that you came to Geneva, and the floor is yours.
Thank you very much. So I will use this microphone, or I just speak without my...
Both are working. Yeah, so I can turn it on.
Good, excellent. Okay, well, first of all, in French would be Je suis enchantée. L'invitation, merci beaucoup. And thank you very much for hosting me today here at the Water Hub. And in particular, I would like to thank, Mara Tinino and Laurence Poisson de Chazoum, because, they are great friends of mine after having worked in the Silala case for 6 years, a little bit more than 60 years. And I'm really glad to be able to share my views with you about this topic the role of science in the resolution of international disputes regarding water resources, because the experience in the Silala case gave me a certain approach to how, in case before the ICJ, you have to handle the scientific evidence. So I think that we could share our experience, Mara Laurence, which was very interesting indeed. So, as you see from this slide, I think that science has been present in every single dispute regarding international water resources. Since the very beginning, since the diversion of water from the Meuse case in 1937, and then the Lake Lanu arbitration in 57, and the Gaptikovo-Nejimaros case, and the pulp mills case, and Kitenganga arbitration, and well, and the most recent one, the Silala case. So, a review of all these international case law, I think that should lead us to conclude that the interplay between science and law sometimes puts science a little bit in the background, while law normally gets all the attention in a case before an arbitral tribunal or before the ICJ, at least when you read the judgments. So if you go through the judgments, normally you would have some quotes from the scientific reports, or you would have some assessment of the science by the tribunal. But really, you don't get to grasp really how important science was. Because it is normal that, after all, judges normally are lawyers. Therefore, they will not get into the assessment of the scientific evidence with the eyes of a scientist. So normally, science will be a little bit downplayed within the judgment. So if you want to grasp really the role of science in a case, I think that one has to read the pleadings and all the annexes, which is a lot of work. I know. So most of the people writing theses or writing about water courses, I'm sure that you don't go through the details of the pleadings and all the scientific annexes accompanying the pleadings. But if you go through that, the amount of scientific information and data produced in the context of these cases is overwhelming. And I think that many interesting things might be taken out of that information. So let's have a look, quick look to the cases. Well, first you have this case, the River Meuse case between Belgium and the Netherlands. In that case, well, both parties were undertaking certain works on the river. And really, the judgment does not go into details with the science. The court, in this case, the Permanent Court of International Justice, was more worried about the interpretation of the 1863 treaty. So you can see that the court assessed the effects of these various engineering works on the river, diversions, locks, the enlargement of canals, and the alteration of the level of the river. But insofar as all that human intervention was within the contours of the treaty, the court said, okay, the two parties are allowed to make all these waterworks. Then you have the Lake Lanu arbitration. Very interesting, really, case. and also a very important case for water law. Here, the case concerned the diversion of the waters of the Lake Lanu and its restitution then back to the Carol River. And France assured that the project will not cause harm to Spain, insofar as the volumes of water crossing into Spanish territory will suffice to meet the needs of the Spanish users, mainly people involved in agriculture. So there was a little bit of, the water diminished a little bit, the water crossing the boundary, but it was not significant. The project involved engineering works, the description of which makes it evident that the amount of technical and scientific considerations that were taken into account in the design of the scheme of water utilization by France. I found this picture on the internet. So I guess that was the dam that was built in order to use the lake as a reservoir. I don't know if this is the same as 1957, but let's assume that this was a sort of waterworks that they were building in the Lake Lanu. So this project involved the construction of a large reservoir in the lake, the diversion of waters of the Carol River into another river in France, and then the construction of an underground tunnel to restore a certain amount of water to the Carol River upstream of the intake of the Canal Quicksilver, allowing then the waters to go back to the main channel and cross into Spanish territory. That is what you get when you read the judgment. Then you have the Gavtikovo-Najimaros case. Again, you have a treaty, the 1877 treaty between Hungary and, at that time, Czechoslovakia, today Slovakia, and they agreed to build a complex hydroelectric project on the Danube. And 22 years later, Hungary decided to suspend the works. As you see, it was a big project because 20 years since the signature of the treaty, still the parties are building the works that they have agreed on. And Hungary, in this case, claimed that the project would cause significant environmental damage in its territory. Everybody here probably knows the details of the case because after that, Slovakia, which was in real need of the hydroelectric energy produced by this project, decided to make some amendment, unilateral amendment to the project in order to put at least one of the hydroelectric plants into work. So they decided to divert the Danube at a certain point in order to take the water to the reservoir, and then the water comes again, is restored to the river. But that was not exactly allowed by the treaty. So in the end, the case was a lot about treaty interpretation and treaty compliance. So the court said, well, is a breach or not of the obligations between the parties? But the interesting thing is that as here Hungary is basing its case on alleged environmental damage, then the court had to go into the science. Hungary, for example, said that the groundwater level would have fallen, causing detrimental effects on the quality of the water. As for the surface water, Hungary said that there were risks of eutrophication, particularly in the reservoir, instead of the old Danube, and there would be, the river would be choked with sand, The fluvial fauna and flora would have been condemned to extinction. As for Najimaros, Hungary argued that if that dam had been built, the bed of the Danube upstream would have silted up, and consequently the quality of the water collected in the bank filter wells would have deteriorated in this sector. The operation of the Capticovo power plant in peak mode would have occasioned significant daily variations in the water level of the reservoir upstream, which would have constituted a threat to aquatic habitats in particular. Erosion of the riverbed downstream was also highlighted. And the water level of the river would therefore have fallen in this section, and yield of the bank filter wells, providing 2/3 of the water supply of the city of Budapest, would have appreciably diminished. Therefore, this would cause in the end a real problem for the population in Budapest. Therefore, everything sounds very serious. And from all these predictions, Hungary concluded that there was a state of ecological necessity. And then the court took that argument in order to try to combine here these facts and the interpretation of the treaty, the 1977 treaty. Therefore, the question was, is the state allowed to suspend or to simply stop its obligations within a treaty on the basis of a state of necessity? So it's a very good case for studying the IELTS. At that time, well, the articles on state responsibility, Article 25. So I think that in this case, there was a tendency that you can see in how the court approached the case to move towards the law instead of staying with the science. So in the end, the court said, well, the Hungarian argument of the state of necessity could not convince the court unless it was at least proven that a real, grave, imminent peril existed in 1989, and that the measures taken by Hungary were the only possible response to it. Then it continues and says both parties have placed on record an impressive amount of scientific material aimed at reinforcing these respective arguments. Therefore, you can see that the annexes were enormous amount of paper. The court has given most careful attention to this material. Well, I don't know if they read everything. But they said, okay, we gave most careful attention to this material, in which the parties have developed their opposing views as to the ecological consequences of the project. It concludes, however, that, as will be shown below, it is not necessary in order to respond to the questions put to it in the special agreement for the court, to determine which of those points of view is scientifically better founded. So you have a competition of scientific reports. It's overwhelming, probably. I mean, the two hired scientists, technicians, and it's true, the amount of information was too much. What does a tribunal do when the tribunal is faced to so much scientific information? And you have to be the judge, because this is an important question which any judge will ask himself or herself. Am I prepared to assess all this information? I mean, I have a degree in law, I am a PhD in law, so I cannot tell really who is right in terms of science. So I think that it is very normal that tribunals will take this particular approach. That, okay, your scientific information is very, very interesting. And probably each of you has a little bit of, is right at a certain extent. So I will go and stick to the law because it's the place where I feel safe, you see? And I think that that is what Eptikovo explains to us. So the conclusions of the court in this case was, well, the court concludes foregoing that with respect to both Nachimaros and Eptikovo, the parents vote by Hungary without prejudging their possible gravity were not sufficiently established in 1989, nor were they imminent. So you see, the court still is putting a lot of emphasis on Article 25 of the Articles of State Responsibility. And that Hungary had available to it at the time means of responding to these perceived perils other than the suspension and abandonment of works with which it had been entrusted. So Hungary, the court is saying, Hungary, you did not get to the threshold of the state of necessity in order to suspend the works. So very legal. Well, another famous case, the pulp mills case. So here again, lot. Well, here Florence probably could tell us because she was working for Argentina at that time. So she was one of the counsel for Argentina. Well, in its application, Argentina charged Uruguay with having unilaterally authorized the construction of 2 pulp mills on the river Uruguay without complying with the obligatory prior notification and consultation procedures under equity, under the 1977 statute of the river Uruguay. Argentina claimed that those mills posed a threat to the river, its environment, were likely to impair the quality of the river's waters and to cause significant transboundary damage to Argentina. So both states submitted the case to the ICJ on the basis, Argentina really submitted the case to the ICJ on the basis of the 1977 statute, and they accompanied technical scientific reports in support of its submissions. Again, an overwhelming amount of reports. In the pulp mills case, you know that there was a lot of criticism, particularly with regard to the relationship between science and the legal aspects of the case, because the scientists involved in the case were a part of the counsel, the counseling provided to the parties. So they were part of the team. And as counsel, you are not available for cross-examination. Therefore, the scientist could not be cross-examined by the court nor the other party. And an interesting topic arisen in this case, which was this interesting thing about ghost scientists. Because in order to access all this scientific information provided by the parties, we know that the court needed some assistance because they are not scientists. They are normally politicians or lawyers. Therefore, someone was assessing this competition of scientific reports. So someone was an advisor to the court. Nobody knew who they were. And the important thing is that they were not available for cross-examination by the other party. So this case caused a lot of, we could say, caused a certain debate about the role of science and scientists in particular in cases before the ICJ. And then we have the Kishinanga arbitration. This is interesting because here a scientist or an engineer was part of the arbitral tribunal, which was Howard Witter, which now I know well because he was one of the engineers working with us, with Chile, in the Silala case. So this case concerned India's construction of the Kishinanga hydroelectric project, which considered the diversion of certain rivers. And here you have a map. Pakistan objected that the project would breach the obligations of India under the 1960 Indus Treaty. And Pakistan triggered arbitration. Pakistan asked the tribunal to stop India from bringing the reservoir level of the Kishinanga hydroelectric project below debt storage level by using certain sediment control techniques in any circumstances, except in the case of an unforeseen emergency. So it was a very, very technical scientific case. It's interesting, the tribunal made a visit to the place. So if you go into the Permanent Court of Arbitration and you click on the Kishinanga arbitration, you will find pictures of the judges going to visit the area. Very interesting. And now here you have a scientist sitting in the tribunal. So maybe he played the role of the advisement to the court, explaining all these scientific reports. Okay. So before we go into the Silala, I think that after this very quick revision of these cases, we could say that in all of them, science played an important role, but the tribunals really didn't go into depths of the scientific evidence. And this means following. Well, this means that I think these are my ideas. I think that if the scientific evidence is conclusive, then the court will certainly rely on the science for its decisions. If the scientific evidence is not conclusive or easily understandable, and there are various open possibilities about the effects of certain human interventions on international watercourses, then the tribunals would have a tendency to put more emphasis on the law, on the interpretation of the legal texts, on the treaties applicable to that particular watercourse, as the Gatsbobo case, I think, demonstrates, and many others. But it's particularly the Gatsbobo. So now, in my own experience, I have had the opportunity to deal with this relationship between science and the law very closely in my capacity as agent of the Republic of Chile in the Silala case before the ICJ. I already told you, Maratinino and Lorenz were also part of the legal team. They acted as counsel for the Republic of Chile in that case. And we learned a lot. At some point, I said to myself, oh, maybe I should be a geologist because it's much more interesting than law. Because it's beautiful. And here you have a picture of the area, which is beautiful, I think. This is the Atacama Desert in Chile, one of the driest places on Earth, or the driest place on Earth. It's beautiful, but it's dry. And also it has something else that is very interesting, something that our hydrogeologist, Dennis Pitt, told me. He comes from Britain. So I told him, well, you are a geologist, so what do you think about this fantastic landscape? And he said, well, it is fantastic indeed, because in Britain, of course, we are geologists, and we study all these structures, the rocks and all that, but everything is covered by vegetation. Well, here, everything is naked. So you go and look at a mountain, you look at a rock, and immediately you know what you want to know. So for example, here you have a volcano, the Inacaliri volcano, the one with the snow. And of course, you know that the Nazca Plate is going underneath the South American continent. Therefore, all this pushing created these mountains, the Andes, and these volcanoes. And that was 5 million years ago. And I said, well, no, 5.2 million years ago. And I said, why not 5.6, 4.9? How do you know? So it's very, very interesting to be there. And here you can see many things in this picture. We took this picture from Cerrito Silala, a hill, which is the boundary between Chile and Bolivia. Therefore, we had to climb with Mara and Lawrence. Cerrito Silala is 4,800 meters above sea level. And Mara was sick. I said, Mara will die. She was with nothing. And Lawrence, living here in Switzerland, was dressed as you see. And she was the first to get to the summit. So I said, well, that is what living in Switzerland meant. Okay, so we arrived there to the top of Cerrito, and we took this picture looking at Bolivia, as we were not able to cross into Bolivia without Bolivia's approval, and we didn't want at that time to make much movement because we were thinking of going to the court. But before Bolivia knew that we are going to submit our case, so we didn't want to ask passing into Bolivian territory, so we got to the summit. And here we have the picture. Also because I approached Howard Witter in May here in Europe. He was in The Hague for a seminar at the International Court of Justice. So I told him if he was available to work with Chile. I came with a lot of reports about the Silala because Chile had a lot of scientific information. And he told me, well, in principle, yes, I will have a look at these reports. Well, your reports are very good. I think that indeed this is an international river. But in order to really assess whether or not I'm available, I need to visit the site. That's why we organized this visit in May, late May, or in the middle of May, to the Silala. And you can see many interesting things here. First, let me tell you what the case was about originally. Originally, the case was this. Bolivia said that the Silala River, which is very small, but this is a river in the middle of the driest desert on Earth, so water is very valuable, despite the fact that it is very small. And Bolivia said, those waters that originate in Bolivian territory do not cross to Chile naturally. These are Bolivian waters. And today, in the 20th century, 21st century, they crossed to Chile only because of an artificial diversion. That was the case originally. So Chile is stealing the waters from Bolivia. And they should compensate for this. They have been stealing the waters from Bolivia for 100 years. So they should stop, and also they should pay for all the waters that Chile has used for 100 years. And we went there, and as you see, there is a volcano. I don't have a, no, because also, but you see there? Yes, you see that. So here you have the volcano. And here you have lava, okay, this black thing of the many eruptions that maybe this volcano has had. And then here you can see that you have these yellow grasses. Well, there you have springs. So water, so there is an aquifer, of course. And the water is coming up naturally to the surface. And when it comes up, there is a very small wetland. Okay, and then you continue, and you see that there is a ravine. Here also you have a yellow, so also springs, water coming to the surface. And you have this ravine. This ravine is not man-made. This is a fluvial ravine that for probably thousands of years have been formed by this running water. And the boundary is from the top of the volcano to the Cerrito Silala. So the boundary more or less goes like here, like there. So when you see this from the top, you say, well, no way. I mean, the water is falling down to Chile, because if you look here, all that land, you can see it goes up, and the water cannot go up. The water normally follows the rule of gravity, so it will go down. So it was very clear. And Howard Witter said, well, after seeing all your studies and all that and this, yes, I can work with you. So here is a map of the Silala River Basin. This is the Atacama Desert. Here you have a map, Peru, Bolivia, Chile. So this is the really northern part of Chile. Here you have the boundary in red. And there is a small river called Silala. It crosses into Chile, then it forms part of the Rio San Pedro, and then the only river in this area, the Rio Lanu. It's the only one. Here you can see a city called Antofagasta. It's a port city. From Antofagasta to Silala, you have 400 kilometers. Antofagasta is important, and all this area is important, because there you have the mines of copper, but there's no water. So in order to make this city a city that can sustain human life, you need water. So at the beginning of the century, in this area, there were some people called water hunters, looking for water everywhere. And a water hunter found water here, the Silala, 400 kilometers from Antofagasta. And in Antofagasta, there was a company, the Antofagasta Bolivia Railway Company. The company founded in 1888. And at that time, it was a steam engine. so they wanted water for the engine. But also they wanted water because the other business of this company was selling potable water to the population of Antofagasta. So they found this, and this company collected all the waters it could find here in Chile, and they took it through a pipeline to Antofagasta. So it was interesting, the history. And the same company also asked for a concession from Bolivia, because as you see, the Silala, or the origins of the Silala are in Bolivia, so they obtained that concession. And also the authorization to take the water, to use the water in Chile. So that is a little bit the history of the river basin. So the regional case is, well, Chile is diverting the waters of the Silala into Chile. The waters will stay in Bolivia, in this wetland, and the water will not cross the boundary. So it was important, first thing important, was to know the topography of the area. And this is the topography of the area in this profile. So the springs are at 4,420 meters above sea level. And the boundary is at 4,100 meters above sea level. So in 2 kilometers, you have really a very big gradient. Therefore, our scientists were able to put all this information in our presentation to the court. Here we have the basin of the Silala River. So we know exactly how many square kilometers we're talking about. Here we have the volcanoes, in Acalide, here we have another volcano. So, and the geologists said, we have to show to the court the history of the Silala. So it will be good for the court to know how the Silala was formed. So we made a lot of studies on that, but mainly the topography. We got satellite images. So today, this is one of the technologies on which you can rely in a case like this. So here we have a beautiful Google Earth picture, but we also obtained some other images from the different satellites that are on top of our heads. So here's beautiful. Here you can see the wetland, and you see the ravine. Here we took a picture towards Chile, looking at the ravine, which is absolutely natural, not man-made. And we had these topographic profiles showing the different heights of the terrain. And the green, the high peaks are in red, and the rest go green, 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 until it is almost black towards Chile. And it was only in 1989, the first time that Bolivia denied that the Silala was an international water, claiming then that it was exclusively Bolivian. And that was the original dispute. So we had a lot of science for this dispute, a dispute that started in 1999, and that by 2016, we decided to take to the court. Why we decided to take it to the court is because Bolivia at that time, on March 2016, President Evo Morales said, well, I already have a case before the court regarding the sovereign access to the sea, but I will have a second case before the court. So Bolivia will sue Chile for the illegal diversion of Bolivian waters into Chile and for the compensation. So that was the situation in March 2016. And then we said, but Bolivia is wrong. This is an international river. And also we had the other case. So we thought, here we are in urgent need of legal certainty. It is important for Chile and Bolivia relationship to have legal certainty, at least on certain things like water resources. So we will go to the court asking for a declaratory judgment. And also, we will ask the court to say, well, this is an international river, therefore, the rule applicable is the principle of equitable and reasonable utilization. The two riparian states are entitled to use the waters of the Silala. And there were a lot of science involved in our memorial in the context of this original. So we showed the topography, we had hydrological data, we have hydrogeological studies, we made a geological survey, geophysical surveys, hydrochemical sampling of the springs. So there is no river in the world that is as known as the Silala, despite the fact that it is very, very small. But we even show the interconnections between the aquifer, the river, so, and we use state-of-the-art technology, which was so interesting. So, for example, there was an optical cable that we put on the river to measure the temperature, because at some parts, the Silala was very cold. And then you put your hand here, and it was like warm. So it meant that there was an interplay between the surface water and the groundwater all along the river, because there is an aquifer there. So we showed that. So it was beautiful. It was so beautiful that now our Witter and Dennis Peach, they will be the editors of a book with all the scientific studies. Because, students of geology, hydrology, engineering can learn a lot from what we did in the Silala. Here we have the catchment area. We put some instruments in the area. There you have. Here you have Alan Boyle, which was also one of our council. We put some state-of-the-art, really, instruments for measuring evaporation. So we spend a lot of money. There you have this. So there is a police station in Chile. So we asked the carabineros, please take care of these instruments because they are really expensive. So we don't want someone to come and take them. So fortunately, they survived. They survived the smugglers that use these territories sometimes to crossing between Bolivia and Chile. So here you have all the things that we installed. And here you have the ravine. And also we used C14 to have the ages of the different terraces. So we were also able to know the geological history of the ravine. You see, and we got to the conclusion that at least from 8,400 years ago, probably even older, but at least 8,400 years ago, there was water running from Bolivia to Chile, and probably at that time there were wetter seasons at that time. So probably the river was bigger than it is today. Today it's very, very small. It's 1 meter wide, 1 meter depth. So it's really small, but it has been very important even for human habitation because that's the river. There was an archaeologist also working with us, and we saw this type of formations. They look as refuge for the indigenous people living at that time, and it was incredible. But we found this arrow. made of bone. It was really interesting. So, and I was happy because I was there when the archaeologist said, look, I found this. So maybe this area was used by the indigenous people to take their cats or their animals to the other side. Well, at that time there were no boundaries, no Chile nor Bolivia, but they used to bring probably the animals here for water and then come back further down. So it was a beautiful, beautiful work that we did. What happened when we received the answer by Bolivia? Well, the answer was, yes, the Silala is an international river. We said, well, this is the shortest case in the history of the ICT. Thank you very much. Thank you very much. Thank you very much, France. We did an excellent work in our memorial. Okay, it is an international. But, and here comes a new case. The new case is there is a network of channels. We cannot see it really on the picture, I think, on the big picture, but the company, the Chile-Bolivia Railway Company, over here, this area, they built some channels that are also 1 meter wide and 50 centimeters deep. And in order to make a more, I would say, efficient use of the water, because you have the wetland. Okay, so the Bolivia's case was that those channels, and you see, and also the company put some stones on the walls of this river in order to keep it straight. But only on the walls. For example, there's earth, soil on the bottom, no concrete, but some stones. So they said that channelization, very rudimentary channelization, built during the 1920s on Bolivian territory, or in Bolivia, I guess, on Bolivian territory, that has modified the river. So today we have an enhanced flow because the channelization has produced an extra flow of surface water, for which Chile has to pay. And then we say, well, but what's the legal thing here? They say that we have more water on the surface. Let's say 20, 35, 1%, whatever number you can put. And Bolivia said, yes, and Bolivia has sovereignty over the extra flow. That was the case. And they hired the Danish Hydrological Institute, and the Danish Hydrological Institute made a very sophisticated geological model, because that is their business. They sell this to the general public. I mean, this modeling that they have been able to develop, and it is not, it's also expensive. So we had a model, sophisticated model, to show that there was an extra flow. And then we said, yes, but I mean, nobody is bringing water from another basin. So, yeah, okay, let's assume that there is an extra flow, surface flow. Where does the extra flow comes from? Well, the only possibility, of course, is the aquifer. So let's assume that the channelization makes some more water from the aquifer to come to the surface and cross to Chile. Yes, the problem is that all the water goes to Chile. The surface water and the subterranean water, the groundwater, because there is a topographic gradient here, and there is a hydraulic gradient in the aquifer. So all the water goes to Chile. So what is the point here? You cannot claim property, you cannot claim sovereignty over water that anyway will cross to Chile. So at that point, we were faced with this interesting question. How are we going to deal with the interplay between Bolivia's legal case, this new case, sovereignty over an alleged extra flow, and the scientific case? Because of course I can make even more technical studies, more scientific studies. I could bring another model to compete with the DHI. But for what purpose? To show what? To show that the extra flow is not 30 to 40% of the surface flow, but it's 5, but it's 10, that is 1%. So we decided that we were going to put the emphasis on the legal case. But we could not leave the scientific case alone. So we had to also to make the most, I would say, detailed analysis of the DHI hydrological models. So we got into the, I don't know, we really made it run. So we had to buy the models from DHI because they are the ones that develop that and they sell it to the market. So we bought the model and then we ran it with all the information that we had. And that was interesting because then we got different results. There was a little bit of extra flow, according to our scientists. First, you had a little bit less evaporation, 1% of the flow. And then there was a little bit more groundwater because there is a drainage effect on these 50 centimeters, as in the countryside. When you go to the countryside, you will see when you have these channels, earth channels, there's a little bit of drainage, but on a very, very limited area. I would say 5 meters from here, 5 meters from here. So that was another 1% or 2%. So we said it is 3%. And anyway, all the water goes to Chile, either on the surface or the aquifer. Therefore, we said, well, the problem here, and we said it to the board, is that you have a hydrological model. And in the scientific language, I think that normally scientists say, when you have a model, you can have a case of rubbish in, rubbish out. Therefore, you cannot really rely entirely on science. Science is a human activity, and you could have this. Therefore, without disregarding the scientific case, we really put the emphasis on the legal case. And we took the models, the results of the models, very seriously. We ran them. We really got to some conclusions, and we showed that. Well, and we got to the oral hearings. And in the oral hearings, it was amazing because the case changed for a second time. And here, when we were able to cross-examine the experts, that was interesting. Having the experts before the court. That was like in the movies, you see, very interesting. And here we have an answer by the expert of DHI. And the expert said, well, with and without the canals, groundwater, surface water will go from Bolivia into Chile. All the water. Which was what we wanted to show. Okay, the total underground will go into Chile. And that was during the oral hearings. And then Bolivia also admitted that the alleged artificial enhancement has no bearing on the applicable principles of international law. So all the waters were under the principles of equitable and reasonable utilization, existing customary rules. And in the end, the lawyers of Council for Bolivia also recognized that we were in agreement that this is an international river and that the principle of equitable and reasonable utilization applies to all the waters of the Silala. And this took us here. That the court said, well, you're in agreement. So this is like the look test cases. You're in agreement. So the court finds that the parties have come to agree in substance regarding a claim or counterclaim. It will take note of that agreement in its judgment and conclude that such a claim or counterclaim has become without object. Therefore, but that was what we wanted. That Bolivia agrees before the court. So there is an agreement between the parties reached before the court by the agents and the lawyers' council of Bolivia saying, yes, this is an international river. This is not only a river, this is an international river system. The surface and the outlet. So, Chile said, well, we are satisfied with the judgment. So that is the history of the Silala case, and I hope that you have enjoyed this story because it's really nice to tell you what we learned from the Silala case. Thank you very much.
Thank you so much. I could have listened to you for another few hours. I agree. I'm also tempted to change my discipline. However, you've told it so appealingly that maybe we'll stick to law and just incorporate some science into it. So let me maybe start with questions from the room, and then those of you who are online. I'm not sure what the easiest way to do it. Do you have a view of who's?
Because there are no questions.
Okay, so those of you online, if you'd like to ask a question, maybe the easiest thing is to put it in the chat. Yeah, if you indicate in the chat, then we can give you the floor in the second round. Would it be okay for you if we collect maybe 3 questions at a time?
Okay.
Yeah, is that
Yes, that's okay by me. Yes.
Just so you know it. All right, and maybe I could ask everyone to just briefly introduce yourself. I know not everyone needs to introduce themselves, but. Mark? Oh, we have 2 Marks. Yeah, so let's start here and then the question about.
Mark Mufti, I'm a professor here. I just wanted to know if there are, at the present time, local populations living in the area. Right now, I know in the past there were, because it was there was more rain or whatever.
Mark Zaytoun, Director General of the Geneva Water Hub. Thank you. I agree, that was an absolutely fascinating, a riveting lecture. It was a very interesting case, and you presented it in a way that was showed a command also of the non-legal aspects. And I have lots of questions, but I'll limit it to one, and that would be what's interesting to me is that here we have the law and the court provides a forum for actually resolving a conflict without making a judgment. And the process itself is good enough. And so that suggests that scientists and lawyers who advocate for one side, if they're in a certain type of process, could actually come out to a peaceful resolution, rather than the perspective where it's always seen, where it's always going to be combative and there's always going to be one loser. So I wonder just your general thoughts on how advocating and taking sides can actually lead to peace as opposed to neutrality.
Take one more question in this round. That's okay. Yeah, go ahead.
Henry Weidler, I'm a second year student in International Affairs here at the Institute. Thank you very much for this fascinating presentation. It was a great pleasure listening. And I wonder, what would you say, what is the reason for why Bolivia essentially gave in to the Chilean demands? Were they really just so convinced by the evidence you presented? Were there any strategic considerations that changed on Bolivia's side? So I'd be curious to hear if you have a personal opinion on what essentially led to this outcome.
Hey. So
Go ahead, yes.
Well, thank you very much. Very, very interesting questions. Let me tell you. Well, I will start first with the users and the population. This area is in no habitation really in this area because it is the driest desert. Probably in the past, we don't know. But it seems that the people living here were a little bit nomadic, taking their animals to where there was grass. And probably at certain times of the seasons of the year, there was grass here. In fact, in the Altiplano, which is this area, in February, January to March, I think, it's the wet season. So there is a very, very little rain, but only at that time of the year. That's why you have permanent snow on top of the volcanoes. So that volcano is 5,000 meters above sea level, permanent snow. So there is infiltration during the whole year, but during the wet season, it's very wet. In fact, it's called the altiplanic, and you can have flooding here. So I think that probably in the past, the indigenous people took their animals to here for breeding and for the grass. Now, apart from that, there are no signs of human habitation of a town or a village or something like that. What is true is that by the beginning of the 20th century, in the 1900s, there were some towns and some mining activity. And for the mining activities, they needed water, but near the coast. So, for example, the biggest copper mine in Chile, in the world, in fact, is in the area of Antofagasta, who is Chuquicamata, exactly. So, once there was industrial exploitation of copper, the mining camps needed water. So, and they took the water from any source they could find. And as you see on the map, the only water resources here are these rivers. The Silala that is a tributary of San Pedro. San Pedro is a tributary of Loa. And the towns are exactly located near those water resources and no more. And the rest is desert, incredible. So Chuquicamata took water from these sources and the other mines. For example, there is Maria Elena, which is another important mine. Tocopilla, and you see most of the towns are near the sea. There is a football player, famous, was born in Tocopilla. His name is Alexis Sanchez. So just for you to know, and he plays in Italy. Okay, so now the process. I think that this case teaches two things, I think. One is, had the parties been able to communicate between themselves before going to the court,
The lawyers.
no lawyers involved, and had them been able to do jointly the scientific studies, we will have reached agreement between us. And in fact, in the history of the case, Chile proposed many times, let's go, the topographers of the two parties, let's go and measure the topography. Even at some point in the early 2000s, there was some possibility because there was an aerophotogrammetric flight conducted by the two states. So Chile put the airplane and it took the pictures and they had the data. But in the end, Bolivia resigned. I mean, they said, no, we don't want to continue with this study. But the topography of the area is enough to know that the water goes downhill. And they didn't agree. Therefore, I think that the problem with this case and with many other cases in the world is the lack of communication between the states, the bad relations between them. And as you know, unfortunately, Chile and Bolivia had a dispute, more than a dispute, problem with a political problem, which is that after the War of the Pacific in 1879, Chile acquired territory from Bolivia, and Bolivia became a landlocked country. So, and that is the real problem. Let me look at the map. What's the map of Bolivia? Here, the small map. So here we had a war. Part of the territory, for example, until there, it was Peru, and then here you had Bolivia. And unfortunately, Bolivia became landlocked. And that has been what we call the maritime aspiration of Bolivia, to get a sovereign access to the sea. That is the problem. Therefore, we were unable for all these years to come to terms with Bolivia and to collaborate in many other areas. So there you can see that one important political issue may have an effect on many others. As for example, the cooperation with in relation to water resources. That's why we were able to talk about it. And in the end, finally, we went to a court. Now, the second thing, it is probably good that at least you have the possibility to get to a tribunal, because then the fact that there is a third party that might be able to give a judgment, that aspect, that case, that fact is important. Because here I think that it was the process that helped the parties to finally get to an agreement during the oral pleadings. So maybe it was worthwhile going to the court in the end.
Yeah.
In this specific case between two countries that they were unable to solve it by themselves. Okay.
There was one more question. Would you like it to be repeated? Or did you?
There was a third question, which was, what do you think that
So essentially about Bolivia's strategic considerations, or what the reasons were why they conceded so much.
Exactly. That's the last question. Well, I think that for Bolivia, this case and others regarding waters, because this is not the only dispute between Chile and Bolivia regarding shared water resources. There is another famous dispute regarding another river further to the north called Lauca. That is a dispute of the 1950s. And again, there Chile, the river, in this case, the river comes from Bolivia to Chile. The Lauca goes from Chile to Bolivia. And Chile was using the Lauca. And in fact, it diverted part of the Lauca to take water to the coast. And Bolivia said, you cannot do that without my authorization. So it's sort of a right of veto. And it took us to the OAS with an accusation of aggression because we took some water from the Lauca. So if you look at the whole context and the whole picture, I think that this case, as the other, has a political element involved. So it's not only about water, it's not only about who is the owner of resources. In fact, I think it's part of a big picture of putting pressure into Chile. So to say, well, we have to solve the big issue, which is maritime access to the sea, sovereign access to the sea. So we have to solve that. If you solve that, all these other quarrels will end. So it's part of a bigger political situation, I think. And that's why, once we went to the court again, Bolivia said, well, really, I cannot, now that I am faced with the evidence, I'm afraid that we never thought that we were going to be before court. So now that we are before court, I'm afraid that we will have to concede 90% of the case. And that's why the development of this case was as it was.
I think I saw 3 hands in a row, right? You had your hand up before? Go ahead.
Okay, so Philippe Ouellet, second year PhD here at the Institute. So I was wondering, maybe that was the case in the cases of the ICJ that you mentioned, but for example, in Corfu, there was naval evidence on the two sides that was very divergent, and then the court said, well, under the statute, I have the power to send a mission, let's do that. So I was wondering, is this something that happened in those environmental cases? The court decided to send its own experts to see really what was happening, and do you think if it was not the case that this could be maybe a path of solution to help resolve future disputes?
I'm Fabiana, first year PhD here, and I did my master's in the active and reservoir utilization principle and read you a lot, so it's really nice to meet you. And my question is, with the environmental crisis, it becomes less and less clear what the impacts of a specific project would be on a river basin, to the ecosystem and to future generations, especially with the changes in water patterns due to climate change. And there are scientific studies trying to predict as much as possible these impacts. So my question is then, how do you see the acceptance by courts of these more generic and predictive scientific studies, which point to the impacts of climate change, the impacts of climate change that could be enhanced by, for instance, infrastructure built on transboundary rivers? And I see, for instance, in the border between Brazil and Bolivia, now we're suffering, Bolivia especially suffering because of flooding due to hydro in Brazil, and this was present in the environmental impact assessment, but it was said to be too generic and lacking of concrete evidence. But the results are here, and they were predicted before, they were just not considered. So.
Do we have one more question? Yes.
Yeah, my question is about how did the judges in the Silala case take the science evidence? Because you talked more in detail about how they tried to avoid it and focus more on the law in the Quemados case. Here, are there any trends that you saw from this case that could indicate in the future how, or new changes in the way that the ICJ is handling the role of science? Because especially with more and more environmental cases, in the future we need better understanding of how to handle the science in the law cases.
Thank you very much for these questions. Well, they are connected because they are all focused on science. Let me start with the last. So in this case, there are certain changes in how the court deals with the science, because in contrast to the pulp mills, in this case, the scientific experts were not part of the counseling team, so they were independent. That's one thing, independent experts. So they wrote the reports and they said, I was asked by Chile in my capacity as hydrologist, whatever, and to the best of my knowledge, I can say this. I visited the area, I conducted this and these experiments and that, and I assure you that this is what I really think. I mean, I swear to provide you with the truth. I mean, this is what I think is the truth. So I'm not a lawyer for the parties. And in that situation, experts are witnesses, really, in terms of what is their legal status before the court. And therefore, they can be cross-examined by the court, by the lawyers of the other party. So here it was interesting because the court asked them for a summary report of all the results of their reports, summary report of 30 pages. So instead of delivering their speech with the results, they provided this summary report. And then we enter immediately into the cross. And they had to answer questions by the counsels from Bolivia and the counsel from Chile. And also they received 2 questions from the judges, which were Judge Tonka and Judge Donovan. And I think that is not by chance that they were the ones asking questions first, because Judge Tonka, he was pretty much involved as counsel for Slovakia in the Gavčíkovo case, isn't it? Yes. He was. He worked at the Ministry of Foreign Affairs of Slovakia, so he knew a lot about rivers and all that because of the Gavčíkovo case. And Judge Joan Donovan, I think that she has a degree on something scientific, like chemistry or something like that. Therefore, they knew a little bit about science, and they posed very interesting questions. So then you think, well, you really need to know a little bit about science in order to be able to put a question. And normally, I mean, it was only by chance that here we have 2 people that are pretty engaged with water resources, and they asked questions, but it might be that another court doesn't. But that was an important change, cross-examination. Anyway, I think that the question remains, would a court try to find opinions outside the courtroom? Would they ask? And at some point we thought that the court could use its right to appoint its own experts. So remember, Laurence, at some point we said, well, it might be. Given the fact that we have here different views from the experts provided by the parties, we will have an independent expert appointed by the court. And we were happy with that. So that an independent expert will look at the 2 competing positions. The court didn't do that. It would have been interesting to see how then you work with that. Because that independent expert then will also, he or she should also be available for cross-examination. So that would be interesting. Also, we thought if the court would like to have a site visit. But then we thought that that was very dangerous because 4,800 meters above sea level might not be advisable for the court to go there. It's a little bit dangerous, you see, for the pressure. And about the environmental points exactly, and I think that here maybe we have a problem because science is another human invention. You see, so of course scientists study nature, and they have paradigms which they work on the basis of which they work, and of course you would say, well, they are closer to the truth than lawyers, because our job is legal argumentation. But scientists have to find the truth. However, science, as any human activity, depends on the paradigms that you are using, and that can change. And you can see that science has evolved. Things that we thought were true in the past are no longer true today. Therefore, I think that we have to, it's the best position, I think, would be to be a little skeptical also science. As you see, particularly when you have all these instruments for modeling. Modeling are mathematical mathematical formulas, really, of what you put and what you don't put, and then you have a result. And in the language of scientists, it is normal to say, well, rubbish in, rubbish out, because it is like that. An experiment, it is like that. It depends on the variables that you put, the result that you get. So I think that very, very, an advice would be, we have to be skeptical about science. You can find today science for everything. People denied climate change, and you will have science on the basis of that. People can say anything, and you will have always a scientist beside saying what someone wants to hear. Therefore, I think that this is one more tool, but we should be, I think that the challenge is for lawyers and for tribunals, the challenge is to be able to have a method in order to be able to assess science. The kind of scrutiny that you have to do to the reports that you will get. They are not written in stone. They might be manipulated as anything human. Therefore, that is a real challenge. And lawyers, we are used to that. Because we are used to work with evidence and to know that you cannot believe things just because someone is saying that. So, very, very good question. Thank you very much.
I have no doubt that there would be many more questions, but we have reached the end of our time. So let me invite you to join me in thanking Professor Fuentes very much for being here and for engaging with us. And again, thanking our colleagues at the Geneva Water Hub for bringing Professor Fuentes here. Thank you very much.